If you're staying in the United States on a visa, you might think that a small overstay isn't a big deal. But the moment your I-94 expires, a hidden clock starts ticking. And if you spend more than 180 days in the United States, you could be banned from returning to this country. And if you overstay by 1 year, you're locked out of America for at least a 10-year period. In this video, I'll break down exactly what happens when you overstay, why even a short delay can wreck your future plans, and how to avoid life-changing mistakes before it's too late. Hi, I'm Zaira Solano, founder of Solano Immigration Law Firm, and many people worry about what it means to overstay a visa in the United States. Overstaying can trigger serious legal consequences under the United States immigration laws. Courts and Homeland Security have defined precisely how the rules work, and I'll reference the Immigration and Nationality Act, also known as the INA, and key cases like matter of Arabali and matter of Duarte Gonzalez to explain how they apply. Form I-94 is what indicates how long you are legally able to stay in the United States. And if you remain past the time indicated on your I-94 without authorization, you'll begin accruing what's called unlawful presence, and the clock on possible re-entry bans starts immediately. Let's suppose that Maria entered the United States on a tourist visa and she planned to stay here for 6 months. Instead, she ends up spending 9 months in the United States. Once she passes the 6-month mark that's on her I-94 and she didn't extend her status, then she would start accruing unlawful presence. That means she can trigger serious consequences when she eventually decides to leave the United States. Unlawful presence is when a person stays in the United States beyond the period of authorization granted by Homeland Security on their I-94. This is defined under INA Section 212A9B. There are a few ways unlawful presence starts. First, by entering the United States without inspection. From the first day that you're here moving forward, you have unlawful presence. Second, overstaying your visa past the expiration date that's shown on your I-94. And third, failing to maintain your status if your I-94 is marked as, quote, DS, which means duration of status. For most visa holders, their unlawful presence begins the day after the I-94 expires. You can check your I-94 by visiting cbp.gov/I-94. If you were admitted under DS, your unlawful presence starts the day after you violate your status. For example, those of you on a student visa, if you quit school and you stop attending, that's in violation of your status. Every day that you remain in the United States unlawfully can be tracked by Homeland Security. A few days of overstay might not seem like much, but it can start to add up fast. Once you hit 180 days or 6 months of unlawful presence, and then you leave the United States, you trigger a 3-year bar to re-enter the United States. Once you're here for 365 days, 1 year or more, and then depart the United States, you trigger a 10-year bar to re-enter the United States. These penalties are automatic. You don't get a letter in the mail or something that tells you that you triggered the 3 or the 10-year bar. And it doesn't matter why you overstayed. What matters is the fact that you were here with no lawful status. Let's talk about the 3-year bar. You trigger that under INA Section 212A9B little I, capital I. And you trigger it if you accrued more than 180 days in the United States, but less than 1 year. And then you leave the United States, whether that's on your own voluntary reason or through a deportation process. And then you try to come back within a 3-year period of your departure. So here's an example. John came to the United States on a business visa. His I-94 expired, but then he stayed an extra 210 days before flying back home to his home country. Even though he left voluntarily, he is now banned for a 3-year period, and he cannot come back into the United States before the 3 years unless he gets a waiver. If you thought the 3-year bar was bad, the 10-year bar is even harsher. This one falls under INA Section 212A9B, little I, capital II. The 10-year bar applies when you have been in the United States unlawfully for 1 year or more, and you leave the United States on your own accord or because of a deportation process, and you attempt to re-enter the United States within 10 years of that departure. Example, Lisa stayed 13 months beyond her student visa. When she left to attend her green card interview abroad, she automatically triggered the 10-year bar. Even though she left to do things the right way, she was still here for more than 1 year without lawful status and left the United States and is now trying to come back before the 10-year period. For those of you who trigger the 3 and 10-year bar, some of you may qualify for a waiver. And you can apply for a waiver to return to the United States lawfully before your 3 years is up or before your 10 years is up by using 2 different waiver applications. One of them is Form I-601. This is for people who are already outside the United States and have triggered the bar. And the other one is for Form I-601A. This is known as a provisional waiver, and it's available for those of you who are in the United States and know that when you leave to your green card or immigrant visa interview abroad, you will be triggering the 3 or 10-year bar. To qualify, you must show extreme hardship to a U.S. citizen or lawful permanent resident spouse or parent, not a child. You can only qualify for this waiver if you demonstrate you have a parent or a spouse who's a U.S. citizen or a permanent resident, and they will suffer hardship. Some of the hardship that can help you on a case are medical issues, financial loss, emotional or psychological suffering, separation from a family member, or potential hardship that may happen to the children of your spouse, and that hardship will affect your spouse as well. These waivers are discretionary. They require a significant amount of evidence, and so it's always recommended that you consult a trusted immigration attorney before applying for a waiver. Who doesn't accrue unlawful presence? Well, some people are protected from accruing unlawful presence even though they overstayed their visa. This includes children under the age of 18, those of you who have bona fide asylum applications, VAWA self-petitioners, victims of trafficking, and those of you who applied for DACA before your 18th birthday and you have continuously maintained DACA status over the years with no lapses between the expiration and the next time that you were granted DACA. This is also outlined under INA Section 212A9B III, and it's confirmed by USCIS. There's an additional bar that's the toughest of them all, and that's called the permanent bar. This is under INA Section 212A9C. It is the most severe, most difficult form of inadmissibility when it comes to these time period bars. And this is how someone triggers the permanent bar. If you were unlawfully present in the United States for 1 year or more after April 1, 1997, and then you left the United States voluntarily or you were deported, and you returned or you tried to return without inspection, meaning you tried to cross the border illegally into the United States, then you are permanently barred from lawfully entering the United States forever, permanently. The only way that you can come back into the United States is if you wait 10 years abroad and then you apply for a waiver under Form I-212, which is a request for permission to reapply. This particular waiver is very difficult, it's hard to get, and it's only granted in very limited cases. What if you never leave the United States? Here's a very common example. You overstayed your visa, you never left, and now you're married to a U.S. citizen and you want to apply for adjustment of status. Or you have a U.S. citizen kid who's over the age of 21 and now you want to apply for adjustment of status. In many cases, you are eligible to adjust status without triggering the 3-year, 10-year, or permanent bar that I just discussed. And that's because you haven't actually left the United States. This is often an option for adjustment of status that's available to those of you who are immediate relatives of U.S. citizens. The Immigration and Nationality Act defines immediate relatives of U.S. citizens as parents, spouses, and children under 21 of U.S. citizens. So if you're an adult over the age of 21 and you have a U.S. citizen parent, that does not make you an immediate relative under the Immigration and Nationality Act. Here's an example. Maria overstayed her visa by 9 months and she's now married to a U.S. citizen. She can apply for adjustment of status to get her green card here in the United States without ever leaving the United States. And because she never leaves, she does not get the 3 or 10 or permanent bar. She avoids it completely and is eligible to apply for and receive her green card with the entire process all in the United States. There's also a really interesting exception under case law called Matter of Arabali and Yarabelli. It's a major exception and it involves advance parole. Matter of Arabali is a Board of Immigration Appeals case from 2012. And in that case, the board ruled that travel on approved advance parole does not count as a departure for triggering the 3 and 10-year bars. So if you have a pending green card case and you travel with advance parole, you can leave and return without being banned even if you overstayed your visa. An example is Ahmed overstayed his F1 visa, but he married a U.S. citizen. Then he got advance parole, traveled outside the United States, returned. He did not trigger the 3-year bar. Again, because he traveled with approved advance parole. Another recent case out of the Board of Immigration Appeals in 2023 that affects visa overstays is matter of Duarte Gonzalez. In this case, the board confirmed that the clock doesn't stop once the person leaves and returns to the United States. So for example, if you trigger the 10-year bar in 2020 and then you re-entered in early 2024, the bar expires in 2030, not in 2034. That means that you don't have to stay abroad outside the United States to serve your 3 or 10-year bar. But that bar still applies if you try to adjust status during the period. So this decision from the Board of Immigration Appeals corrected older misconceptions and interpretations that are now official guidance under USCIS. And it's important to note that the 3 and 10-year bar running in the United States is affected by the manner of entry into the United States. So those of you who entered legally with inspection may be able to take advantage of this 2023 Board of Immigration Appeals case that allows you to serve your 3 or 10 years in the United States. Here are some final takeaways and what you need to know. Your unlawful presence starts the day after your I-94 expires, or the day that you step foot in this country unlawfully without inspection. 180 days or more means you get the 3-year bar if you leave. 1 year or more means that you get the 10-year bar if you leave. Advance parole travel does not trigger bars. Hardship waivers are available but not guaranteed, and not everybody qualifies. Some groups of people are protected from accruing unlawful presence. The permanent bar applies to re-entry after an illegal return. And you don't need to remain abroad to serve the time if you qualify for the bar to run here in the United States. If you think that overstaying your visa is serious, wait until you see what's coming next. In 2025, there are 4 ways that the government is using to strip you of your U.S. citizenship. Click on this next video to find out exactly how denaturalization could happen and what you need to do to protect yourself.